So we're going to talk a little bit about, liability and how this impacts, because, of course, hunting, we talked a lot about hunting and things, but it's not just hunting, it's all recreational access in general. I want to tell you a little bit about what the law says, and that publication basically, spells out what the law says. In general, I would tell you that Maryland provides pretty good, liability protection for private landowners who allow people to recreate on their property when involved. So I kind of want to expound a little bit on that and talk a little bit about hunting leases, because again, for a lot of row crop farmers, expensive fencing and stuff is just not an option. So in many cases, there is money to be had, from deer in terms of hunting leases, but it needs to be set up properly so that you're protected, with insurance and things like that. So I'll comment a little bit on that. But everything I'm going to talk about is in that publication, Landowner Liability and Recreational Access, which you see right here, which I revised back in 2008 because there were some changes that occurred. So, what type of recreational access? We're talking about hunting here, but again, what I'm going to talk about applies to all recreational uses that you see here, as well as many others that aren't mentioned. So the questions that a lot of landowners have is, what are my rights? How do I exercise them to control recreational use of my property? What's the extent of my liability to recreationalists? And how can I protect myself against liability suits? What are my options for posting my land and controlling trespass by recreationalists? How does it affect my liability? I'm not going to talk so much about trespass, but it covers that. In Maryland, you know that instead of using no posting signs, you can, or no hunting, or instead of posting it with signs, you can basically use the blue strips of paint, and which is great. How do I charge for recreational access and still provide liability protection? And what do I do if someone takes timber from my property without permission? Well, officially they're liable for triple the value of the timber. I'm not going to talk about that here either, except to say that as a landowner, if you want to press that, you have to get someone, a consultant, to determine the value, and it gets very complicated very quickly. Most of those things tend to be settled out of court in many cases. So let's talk a little bit about liability. And I put this as perception, reality, and excuse. So the perception of most people and most landowners is, I'm liable. If somebody comes on my property, they're going to sue me for everything I own. That's what a lot of people think. The reality is that's really not true, but that reality or that concern is also used as an excuse, because if I don't want people coming on my property, I just say, well, I don't want to be liable, because I think I'm more liable than I really am. Does that make sense? So it can be used in a number of different ways. Of course, the most important thing here is the disclaimer. I am a professional forester. This presentation is not intended to be a substitute for counsel from a lawyer or insurance professional. I did share this with our ag law person, Paul Geringer, and he said that it looks okay. So I'm going to take his word for it. 1-800-lawyers. But but the issue is that a lot of stuff is just not known by a lot of people. And if you tend to go to many traditional lawyers, they say, well, you don't want anything to do with any of that. You don't want to be liable, because they don't understand what the recreational statute says either. So general rule of liability descends from English law, and it's based on the visitor's status. And the degree of liability, or the duty of care, depends upon the classification of the visitor. Okay? So if a person comes onto your property without permission, they're considered a trespasser. But if they have permission, they're either a licensee or an invitee. So, what are the differences there, and how does that impact your liability? So let's take a look at that, and then we'll take a look at the duty of care for each of those people, and put that together at the end. So an invitee is kind of like a business relationship. A person comes on your property, and you invite them on. Enter the property for the benefit of the owner. I'm selling them something. They're receiving some services. And that's the highest duty of care that you're going to owe to someone coming on your property. And you have a duty to seek out, discover, correct, and prevent dangerous conditions or activities, and to warn the invitee of those that cannot be corrected. So, if you go into a business, they have signs everywhere about, don't do this, don't do that. They put up at Lowe's, you can't go down this aisle because there's someone with a forklift. Because they have very high duty of care. The one in the middle there is a licensee. And this is where someone has the owner's permission to be on the land to further their own purposes with no particular benefit for the owner. In this case, this might be where somebody, yeah, you want to come over and go hunting? Yeah, no problem. Come on over and go hunting. But in this case, the owner has the duty to warn, but not correct the hazards. Okay? So there's a little higher level of duty there, right? And the owner has no duty to inspect the premises. Okay? So then we go to the third status of user, and that's the trespasser. And this is a person that comes on the property, remains on the property. You don't even know they're there. They don't have your permission. They've just come on the property. And in terms of your duty of care to that person, the landowner owes little or no duty to seek out, discover, or correct unsafe conditions. I mean, you just don't, okay? So that's a very low duty of care. So you have the invitee, you have the licensee, and then you have the trespasser with an increasing level of duty of care for each of those. So the important thing is that duty of care, and you've heard these terms before, okay? Negligence, okay, that's the highest duty of care. In other words, you fail to exercise ordinary or reasonable care. If you're in a business relationship, that person was negligent. They didn't. Almost, anything will basically be grounds for some type of suit. Willful behavior kind of falls between malicious content and negligence. So malicious is basically, most people know what malicious intent is. You're intentionally, you're shooting at somebody. You're putting in bungee pits. And you're really trying to hurt people. And then in the ground there, in the middle there, is somewhat willful behavior. And that's what greatest when a dangerous condition would have been discovered only with minimal inspection. Okay? The point is that each of these is increasingly difficult to prove in a court of law. So what this means is that the status of the user is the problem. Okay? The status of the user and the duty of care can change depending upon the situation. So someone trespasses on my property, hunting, for example. I owe no duty to warn them about anything. Okay? But I invited my neighbor to come over and come hunting. All of a sudden, he's a licensee. I have a higher duty of care to that person. So there's a lot of confusion. Little incentive for landowners to allow recreationalists to enter the property because they don't know exactly how liable they are. And this was a situation for a long time. And this is why the recreational statutes were developed. Some national statutes, templates were developed in the 50s, I think it was. And the purpose of these recreational statutes were to encourage any owner of the land to make the land available to the public for recreational and educational purpose by limiting the owner's liability. And there were some standard ones, and each of the states kind of enacted them a little different. Okay, so the recreational statute in Pennsylvania is going to be a little different than it is in Maryland, the way it's instituted and the way the duty of care works and things like that. So, again, these are all quoting the annotated code of Maryland, and this is all in that publication as well. But the point is, these were developed to encourage private landowners to open up their property for recreational uses, hunting being one of those recreational uses. And the way it did that is that, and this is similar for a lot of the states, all the visitors coming onto your property are considered a trespasser. And what was the duty of care to a trespasser? Minimal, right? So the landowner owes little or no duty to seek out, discover, or correct unsafe conditions. But the caveat here is this only applies when no fee is charged. Okay? So once you charge a fee, you're basically an invitee, right? You're a business. Okay? Then you have a much higher duty of care, and things like simple negligence. You can be found, liable for that. So the point is that when you look at the recreational statute, it covers the entire range of recreational activities and educational activities. So if you have an educational event at your property and you don't charge a fee, you come under the recreational statute because there's no fee charged. And it covers the whole range of recreational activities, everything from hang gliding to rock climbing to caving, and it lists them all in the statute. Pretty much anything you can think of. And of course, hunting is in there. Cutting firewood is in there. Okay. the biggest concern here is what's a charge, all right? So a charge is a price or fee asked for services, entertainment, recreation performed, or products offered for sale on land. Go on. So, and this was a big gray area in the recreational statute in Maryland, and it still is in some other states. And I know I testified in the legislature, and it was really the horse people that really got on this in the early 2000s, because they were concerned about, landowners were concerned about horses coming on the land, people hurting themselves, and the liability. And they basically amended the recreational statute to more clearly define what charge was, because some landowners were saying, well, I don't want these people coming on, or for example, someone's fixing some fences on my property. That could be considered a charge, because I'm receiving, something for it, even though it's not money, for example. So this change basically clarified that and said that, first of all, the sharing of fish, game, or other products for recreational use is not considered a charge. So if someone gives you some deer meat because you let them hunt in their property, that's not considered a charge. Benefits to the land arising from recreational use. I still am not sure exactly what that means, but the most important one is the last one. Contributions in kind or services to promote the management or conservation of resources on the land. So if you work with a hunt club or a group of people, they come in and they fix up some roads, they may do some invasive species control, they may fix some fences. Those are activities that can contribute to the conservation of the property. That's not considered a fee. And when they tried to get this in, they also tried to have something about some cash, but or some minimal amount of cash, but that didn't go over too big. So the point is that this gives a lot of landowners clear sense that what a charge is and what it isn't. And I think it was very beneficial. And this applies not just to private land, but to public land as well. So a lot of parks were concerned about this whole issue as well. Yeah, okay. I would think so, but you would have to ask a lawyer about that. I mean, no, I think it depends on the individual, I would think. I mean, the way you handle, and I'll get into this about the whole fee thing, is that you have some type of a lease or you have some type of a written agreement that defines, even for non-fee arrangements. I'll mention that here in a minute. So the owner of land who directly or indirectly invites or permits without charge persons to use the property or any recreational or educational purpose. So if you have this is very important for extension, you have extension workshops, you're not charging a fee for a field demonstration. It talks about cutting firewood as well for personal use. Okay? So that's interesting. It doesn't extend the assurance that the premises are safe, confer upon the person the legal status of an invitee or a licensee to whom a duty of care is owed, or assume responsibility for incur liability as a result of any injury to the person or property caused by an act of omission of the person. All right? So, but you can't unload all liability. You're always liable. Okay, and it says basically the provisions of the subtitle do not limit in any way which otherwise exists for willful or malicious failure to guard or warn against a dangerous condition. So, and the important thing here is if you are sued as a landowner, it's incumbent upon the person pressing the charges to prove, they have to prove that you willfully or maliciously caused that damage, right? So they have to find, and again, be careful, I'm not a lawyer, right? But from what I understand, and from the civil suits, there's not a lot of these that go into court. Is that a fair statement, Brian, in terms of things? Yeah, I mean, from what I checked into this, yeah. So malicious and willful, willful is probably the more middle of the road, and there's easily to protect you against these types of things by simple levels of risk management. Making sure that obvious hazards are posted and things like that. Giving a map of the property or giving some type, even like a liability release. At least people that they know that you've given them some information about things that they may be concerned about on the property. And the point here is you're always liable. Okay, you never can absolve yourself of all liability. But the point is is for willful, malicious conduct on your part, and that has to be proven by the person pressing the charges. So, and where does this apply? Well, most people think, well, this applies pretty much in rural areas, but one of the reasons for the rewrite was because the Circuit Court of Appeals in 2002 actually applied the recreational statute to a business park. I think it was in Greenbelt, Maryland. There's some guy from Sweden running on the business park. He stayed at a hotel, and the hotel said, yeah, there's a business park over there you can run, you know. And guy's, you know, running in January on an icy day, and I guess banged himself all up and decided to sue the hotel and everybody else. But the circuit court basically said that the recreational statute applied because, you know, they weren't receiving any fee for it. There was no fee for it. So, and the more details of that are in there. So the point is that this doesn't just apply necessarily to rural areas. This concept can apply to, you know, more urbanized areas as well. So the way you reduce liability of future problems is by risk management. Practicing. This is the property I own in West Virginia when we bought it. We call that the chalet right there. So, but you know, you obviously, if things that look like they're going to fall down or they're dangerous, you know, you post things. You know, you enter your own risk. There you go. Okay, that kind of stuff. If there's around here, a lot of sinkholes, you know, putting a little fence around sinkholes, or giving a map to somebody you know is going to be a club or a group that's going to be hunting on the property, letting them know areas they need to be concerned about. So if you are taking the court, that you can show that, you know, I made a reasonable effort to, you know, let people know coming on the property that these are some things they need to be concerned about. So the real thing here is you have to have liability insurance, just to protect yourself, because, you know, if there's anything, there's going to be a lawyer who's going to want to sue somebody. So, you know, you need the real cost for is defending yourself in even a frivolous suit, and that's why you need to have, you know, liability insurance to protect yourself against that. Even if there's no judgment awarded by the court, which there probably wouldn't be, you still could spend a lot of money defending yourself. So that's why you want to have, you know, some type of liability insurance for peace of mind, and make sure the liability provider, your insurance company or whoever, knows what you're doing on your property. You know, let them know that you have hunters on the property, so they're not surprised and they can't, you know, say, well, we didn't know there was hunting on the property. You know, and the point here is that especially a lot of farmers, conventional farm policies, they just need to check with their provider to make sure that that it's covered. Especially now, if they're going to put in some type of a fee hunting operation, they're going to charge a fee. That's typically not covered by most traditional farm policies. And for those, you know, ag and folks, you know, you work with ag folks and they put in some type of pick your own or a farm store, you know, it's a whole different level of insurance. And so I think farmers are much more aware of that these days. But, you know, make sure that they have some type of policy. And for myself, I mean, I've leased my land for hunting in West Virginia for 25 years. And we just have a policy through the Forest Landowners Association. You know, and $2 million policy, it's $250 a year for the hunt club who's there. So this insurance is not necessarily that expensive for hunting. So just about developing some income from hunting, you know, this is based on it's hard to get real numbers, you know, from landowners about how much they may get for hunting leases. But, you know, the numbers of $8 to $30, maybe more like $8 to $20 an acre numbers that I hear here and there. So the point is that for a lot of larger landowners, this can actually provide some significant income. And if you think about, you know, this is not just like a timber harvest as a forester. This is year after year after year income. When you start adding up the amount of money you receive at $10 an acre, even over 20 years, a lot of money. It pays a lot of taxes. It does a lot of other things. So, and the benefits here, you know, people, we were just talking earlier, I get calls many times from landowners. I got people trespassing on my land. How do I keep these people off my land? And I tell them, you're asking the wrong question. You should be saying, who do I want to let on my land? You know, whether I charge a fee or if I have a fee hunting arrangement, those group of hunters that you give permission to hunt on the property, because it is hard to find private ground where hunters can hunt, they will typically take care a lot of times of your trespass problem for you, because they don't want people hunting on their land, on the land that they have permission to hunt on. So, and again, there's a lot of investment that can come, and even if you don't charge a fee, but just conservation practices that contribute to the conservation of the property, and all of these types of things. Again, if you do charge a fee, there's a liability status that you have to take care of that, making sure you're covered. There may be some changes in the farm operation. Many hunters or property owners have people that have hunted the property traditionally, many locals, for example, and you can get a lot of resentment if all of a sudden you lease out your hunting to some other outsider, especially somebody outside the county, and if that's your second home and you're not there all the time, things catch on fire, and all kinds of things can happen. So the point is, in many cases with hunters, it's a good idea if you have people traditionally hunting in the area. It's good to work with local hunters if you can work something out better. Just realize that sometimes you can run into resentment with when you lease land out to other people when there's other people that have traditionally used it. So that's this other stuff I'm not going to go into. Just to say that there's different types of lease. I always recommend people, and there's some sample leases in the book, even if you don't have you're not charging a fee, but you want to lease your land out to a group of hunters, I really encourage people to have a written lease. So at least you know what the expectations are you have of the group and the remedies that would happen in case there was a problem. And you could have something, and it can be redone every number of years. The one thing, and this I got from a lawyer, that if you're dealing with a hunt club, most hunt clubs are not incorporated. They're just a bunch of people who hunt. So you have one person you deal with who's the contact person with the hunt club. Well, that's great, but legally he doesn't represent everybody in that group. So I know with the hunting leases I've had, I always get all the people who are hunting on the property to be notarized on the lease. They get notarized on the lease, not just the person who is your contact person. Whether it's required or not, I mean, I've always done that and encourage people to do that. It seems like a reasonable thing to do. So and having some type of written lease, whether you charge a fee or not, can be a good way to kind of avoid unknowns and to have remedies when you know that there's things that may occur. So these are all things that can be on there. That's pretty much all I have to say about it. The fee is not covered under most farm and homeowner policies. Special coverage required typically. And there are a lot of specialty companies. These are some. The Maryland Forest Association has an arrangement with, I think it's outdoor underwriters actually, forest landowners. Davis and some of these individual agencies just by their own actually sell policies. And I think that maybe even Farm Bureau or maybe even some of the agricultural groups. So you just need to check into it. And what I've found is that typically when you get those policies, it kind of depends on how the property is owned, because like I know some of these will, for example, if you own the property with somebody else, then they charge you amount for each owner. So when you start adding up the dollars, it may be a certain amount per acre, for the insurance, but then they want to charge a additional fee for each landowner. If you have a number of landowners on the property, there could be a significant difference in the actual annual cost depending upon how the insurance is structured with that particular organization. Does that make sense? So just look around. These are just some I know of, and this is typically what they look like. Something like this, $1 or $2 million total coverage. Usually there's fire damages, maybe $50,000 or more, and the amounts just depend upon the organization. So with that, it's. I hope this helps you understand about at least the liability issues a little bit more. I think it's pretty misunderstood by a lot of people, but Maryland actually has been pretty proactive. Adding in that definition of what exactly is a charge was a real positive thing that I think put a number of landowners at ease. So I know I'm coming between you guys and lunch. Does anybody have any questions?